say November 23rd of 2024, around that time, New York repeals a 1907 law that criminalized adultery. So meaning that adultery is no longer a crime in New York, which I'm sure a lot of people were surprised to hear it was until last week. And so the governor signed a bill repealing the statute, which dated back to 1907.
Hey everybody, it's Rayford Palmer, one of the co-hosts of the SG Divorce Law, I Just Want This Done Divorce podcast, here with Rahul Iyer, as always. Hi, Rahul. How's things?
Hey, how are you, Rafe? Good to be here.
Awesome. So we've been gone a little while. We're sorry. We're back after we had our turkey. So we're ready to do episode 22. We got some interesting stuff with today's episode. We're going to talk about celebs like we always do. We love our celebs. We've got Ben and Jennifer, Ashley Darby from Real Housewives. We've got a topic about alimony and spousal support, how that works, how it's done in Illinois, how it might work elsewhere. We're talking about New York's repeal of adultery as a criminal offense, shared custody mandates in various states across the country, and passage of laws requiring shared or 50-50 parenting time and custody. And we're going to talk about some listener questions. So we have a new feature where we're going to take questions from listeners, and what you can do is drop comments to us, or one of the easy things to do is email us at Raif, R-A-I-F, at stglaw.com, or Rahul, R-A-H-U-L, at stglaw.com with questions. We'll pick the best ones and answer them on the next show. So that's a new feature we have. You only have time to answer a couple, but we'll try to pick the best representative questions and answer them. That's it. So without any further ado, I just wanted to talk briefly about, going to go into talk about JLo and Ben Affleck. So you probably already know in the news that they're getting divorced. Not a big surprise. They were married only 2 years. They had a troubled past, as you probably know. They were married just for those 2 years. They were dating before, after the comedy JLo came out. They met each other, I guess, on the set. Affleck proposed. They broke up in 2004 after canceling their September 2003 wedding. They said due to media attention. I don't know. Lopez married Mark Anthony. They had twins. And of course, Ben Affleck married Jennifer Garner. They had 3 kids. They were both married for, 10 years or so. Then in 2021, they got back together and married in Vegas, July 2022, and celebrated their marriage at home in August. And then, of course, over the summer, it came public that they were breaking up. And from our perspective, the good news is that Laura Wasser, who they call the Disso Queen, they mean dissolution. Sounds like a British term for an American person, right? But Laura Wasser's a well-known divorce lawyer in LA, and apparently she's mediating their divorce, which is a pattern that we've seen and talked about in the show for celebs and wealthy people. They typically prefer mediation or collaborative to work out their differences, keeping their cases out of court and getting things done by agreement. And these folks had no prenup, and they both have a lot of assets. Interestingly enough, JLo quite a bit more than Ben Affleck, as we talked about in a previous show. But we saw a story from TMZ that Laura Wasser's doing this. She's handling the mediation, I guess. In other news, couple little tidbits. JLo has a new divorce ring, I guess, and she's been seen with that reportedly. And Ben Affleck is reportedly lasering off his giant phoenix tattoo on his back. A relief to all of us, I'm sure. Now that he's single and back on the market, JLo reportedly annoyed by this because she'd been on his case to get that lasered off before. That'll be quite a project because that thing is huge. So that's what's going on with them. But let's talk briefly about benefits of mediation. It keeps the case private and out of court records, except you do have to get your divorce decree has to get filed publicly. But generally in Illinois, we can keep a lot of details of the divorce private, like specific financial details and other things can be held out of the public record. Presumably you can do something like that in California. Also, you keep your costs down and the acrimony level down, which is important too. So that's a plus for them. So a lot of wealthy people like to work things out like that instead of, having World War III between the lawyers in court and have a big mess. So good on them. Hopefully it works out. It's only a 2-year marriage, but they're going to need to untangle some of their joint assets, like the home they bought together, I guess, during the short marriage. So you were going to talk about Ashley Darby, right?
Right, exactly. And so Ashley Darby is famous from the Real Housewives series, and apparently her and her husband, Michael Darby, are finally divorced after being separated for over 2 years. Key part about this is that despite their celebrity status, they've tried to, for whatever they could, keep this as amicable as possible while also creating, I think, enough drama for the show to be watchable for people on TV. part of what had happened was they have a prenup, and then they were trying to see if they could negotiate a postnup during certain episodes of the show, and then talk about having a postnup or what should happen in possibly what would be party to a postnup. So what stipulations?
They had a prenup, but they wanted to negotiate a postnup and stay married?
And stay married, correct. Or otherwise change what the prenup has to say in the event of a divorce. So they weren't fully sold on that. And I don't know if that was both sides wanted it or just one, it was driven from one person, but that was, I think, part of certain episodes that were occurring. So nevertheless, it doesn't look like that ever got done. They separated and they're going their separate ways now. After 8 years of marriage, they were separated back in April of 2022. And then it was an amicable divorce where they enforced the prenup. And there is word on the street that she got a little bit more than what the prenup provided for by agreement. He wasn't, according to her, leaving her high and dry. They have 2 children, so seems like a very amicable split as far as things are concerned. And some takeaways from this, we say this from day one, which is prenups aren't just pieces of paper. Sign one and know that it's going to be very difficult to undo if you do it right. Celebrities use it, billionaires, millionaires, whatever you want to call it. Everyone employs these tools. And in addition to a prenup, we haven't talked too much about this, is a postnup, which has a slightly different legal, at least in our jurisdiction, has slightly different legal requirements, but functions similar to what a prenup does, which is, again, give you certainty for asset disposition, payment of support, etc. in the event of a divorce. Usually, like you said, Rafe, to try and stay married and salvage the marriage so that you're not worried about how property are being divided and that being the function or reason for the divorce versus trying to see if you can keep that relationship going.
Right. In my new book, I Just Want to Know How Smart, Successful People Decide on Divorce Without Fear, Uncertainty, and Doubt. I'm almost done drafting it. I just talk about that. I talk about postnups, legal separation, temporary separations, and postnups, and how people use them as a tool when there's a loss of trust, an affair, imbalance in financial power, and somebody wants to feel secure. So they use a postnup as a device to do that, but stay married. And we've seen those in the firm before where those kind of issues come up and folks say, okay, I'll stay married provided you give me XYZ assets and some control. They might feel insecure because the other spouse is controlling the money and they feel like, okay, I'm scared because I have no control. This person cheated on me or XYZ bad thing happened where I lost faith. I'm willing to work on this marriage, but under XYZ conditions. And let's say there is no prenup, or maybe the prenup is unfavorable and makes the person nervous in light of developments, or they've been married a long time and the reasons for the prenup may have changed. The conditions on the ground, so to speak, have changed. So they think, well, postnup might be the way to go. So we see those more often. I can tell you in the first 10 years I did this, I didn't hear of them. And now we get questions about them, I would say pretty frequently. The one thing, Rahul, that we warn people about, is a prenup is not a postnup. On Twitter, I've written posts where I write like 5 times in a row. I go, a postnup's not a prenup. A postnup is not a prenup. And why is that important to emphasize for people so they understand? Because I've had people say, well, it's icky to talk about it before the marriage. So we'll just wait till after we're married and we'll do a prenup after the marriage.
Right, which is equal to a postnup.
Yeah, and it's a postnup, right? Because pre-post, then they go, oh, sure. And then, but what's the catch?
Well, the catch is the legal standard by which those documents are judged. So a prenup is a whole lot more likely to be enforced because you have certain legal requirements, certain disclosures, and certain element of, hey, you know what you're getting into at the time you're doing the prenup. This is what this person has. You're signing this. It's a contract between 2 consenting adults, and be careful what you wish for. A postnup, however, you're already married, and so the legal standard is not the same as the standard for a prenup, which is, hey, buyers beware. It's a little bit different. Well, what is fair? There's an element of fairness when evaluating a postnup for validity that doesn't exist in a prenup. And I mean, we could talk about the intricacies of this for a long time, but suffice it to say, a postnup has to be quote unquote fair to both parties. There has to be things that both parties are receiving. There has to be consideration that can't just be getting married. Getting married is a consideration for a prenup. There has to be other consideration for a postnup, value value add that you don't have when you have to do a prenup. So that's a key distinction.
Exactly. The judge is going to look at the postnup at the time you're getting divorced and decide if it's equitable. Was the consideration adequate for the thing that was traded away? Because once you're married, you get all the protections of state law. Let's just be generic and say you get 50-50 division of assets, you get alimony, you get XYZ. And so if somebody's giving up on any of that stuff, the stuff traded for has to have equal value or close to it. And so, yeah, you're absolutely right. So when people say, oh yeah, after the marriage, she'll agree to a waiver of maintenance, or like a waiver of alimony. And you can't do a one-sided postnup. You just can't. I'm exaggerating to make a point. So it's just super important. If folks out there are considering getting married in a prenup, you can't wait till after the marriage because it's an icky subject to talk about. You've got to have the conversation. The other thing too is you have no leverage. After you're married, the other person could just say, well, divorce me. Yeah, I mean, I'm not signing a postnup.
Right.
And then you're stuck. And they could promise you all day long before the wedding that they'll do it. And then just say, no, I don't think so. Now what are you going to do? So yeah, no, I thought it was a useful discussion. So that's cool. Thank you. So we're going to talk about alimony and spousal support. And we'll use Illinois as an example because that's where we practice at STG Divorce Law in Chicago. But we want to talk about it, understand the little basics of it and how it might vary elsewhere, what it is and what it isn't, and some basics. So alimony is also known as maintenance in Illinois. It's also called spousal support. And what we're talking about is support for a spouse who is less financially well off. And depending on your state, there are different ways to compute alimony or spousal support. In Illinois, we now have a state law with a formula that came into being in 2015. It's been amended a little bit since then. And it is basically a simple calculation based on the payor's income. And the payor is the person who makes more money, minus a percentage of the recipients. And by the way, it's net incomes in Illinois. So after tax, minus a percentage of that of the recipient's income. And then that number is subject to a cap. The cap in Illinois is 40% of combined net income for the whole couple. That means the recipient can't earn more income in net between their job or imputed income, which we'll talk about in a second, and their maintenance. And anything above that cap gets cut off and limited to that cap. So as incomes get closer, the cap comes into effect, limiting the ability of the person to receive maintenance or potentially knocking them out entirely. The idea being they make too much money or their income they make is too close to the payor. So it doesn't make sense to pay maintenance. And also child support is taken into account for the recipient and the payor when you're running these calculations. It's in Illinois, it's income from all sources. So it could be investment income, income from real estate, not just job income. And in other states, the formula could be different. And Illinois used to have just a number of factors the court would consider, and judges used rules of thumb to kind of take a stab at what maintenance or alimony should be. And it was kind of the Wild West. Famously, judges across the state would come up with different opinions on the same facts. I was at a seminar one time where they had 5 judges from across Illinois, all the way from Southern Illinois to the city of Chicago. And they gave them the same set of facts. And the judge in Chicago awarded a large amount of maintenance and the downstate judge awarded 0. And everybody laughed. They did it like a game show. They told them the facts. They wrote it down in secret on a piece of paper and they flipped it over at the same time. Everybody laughed because it was all different. And due to the fact that we wanted consistency across the courts, they came up with a statute with a formula. Judges can still deviate from it and do something different if the evidence supports it. But generally, they follow the formula. And that's for people making a combined net income of $500,000. And obviously, that covers most people in the state of Illinois. So it gives you a good idea of how that's figured out. In other states, the mileage varies. It all depends on the state. And also in Illinois, I should say the length of maintenance depends on the length of the marriage. Based on the date you're married up until the date somebody files for divorce, that's the length of the marriage for spousal support purposes. And there's a formula for that. It's just up to 20 years, the length of maintenance is scaled to the length of the marriage. So let's just say that 10 years is 50% of the length of the marriage, and roughly 15 years is 75%. 5 years is roughly 25%. I don't have it exact, but it's close enough for the idea. And at 20 years and up, it's indefinite. It's not permanent because it isn't until you die, until the payor dies, but it's indefinite, meaning the payments will go on month after month until they terminate for one reason or another. Termination events, why it would terminate would be death of either person, obviously. In Illinois, we still have cohabitation. The way that courts have interpreted that is the recipient of support moves in with somebody who lives almost like they're married. So there's pretty much financial support for them, intertwining of accounts, things like that. And a court might terminate maintenance in that case, although that's been drastically limited by court interpretation of that law. Sometimes there's a set number of payments, like I said, under this timeline, where the payments would terminate on their own, or remarriage. If the recipient gets married, that terminates spousal support. So that's how it works in Illinois, generally speaking. You can modify support based on an increase in income, decrease in income, like lose a job or whatever. The person paying support can seek to abate it, sort of put it on pause. They can seek to terminate when they retire if they're at a reasonable retirement age. So that's generally how it works. We have a ultimate guide to maintenance in Illinois available on our website, and the link will be in the description below if you want to check that out. We just take an email address and you get this for free. We explain how maintenance works in great detail. Other states have different laws. Some states are very tough with maintenance. It's hard to get spousal support in some states. Some states are more generous. So it's important to talk to an experienced divorce lawyer in your jurisdiction to find out exactly what the rules are. So, Rahul, did I miss anything on that? Any comments on that?
No, I think that was very comprehensive for our segment here. Of course, your mileage varies, and these percentages, the reason we're not going into, I think anyway, exact percentages for the formula is because the state legislature just steps in and tweaks them every once in a while. So if you listen to this 2 years from now and take our numbers and say, okay, well, that's what I think it is, but the law has changed, we don't want you to have misinformation or old information. So we're leaving it intentionally general. So don't feel like, oh, they told me all this, but they didn't tell me what the percentage was.
Yeah, that's really why you have a consultation with a skilled divorce lawyer like those at STG Divorce Law, stglawfirm.com, is to get information on your specific circumstances, find out what the law is currently, and get the right advice so you have good guidance and you're educated and informed client and consumer of legal services. So moving on, we have the legal news segment now. I want to talk about adultery.
We're talking about specifically how, say, November 23rd of 2024, New York repealed around that time. New York repeals a 1907 law that criminalized adultery. So meaning that adultery is no longer a crime in New York, which I'm sure a lot of people were surprised to hear it was until last week. And so the governor signed a bill repealing the statute, which dated back to 1907. And of course, as you might think, very, very antiquated and also difficult to enforce.
Well, and they said there've been like a handful of prosecutions, like a tiny number of prosecutions over the years.
Exactly. So it basically made cheating on a spouse a crime, which again, a crime, there are different types of crimes. You have misdemeanors, felonies. This would be a misdemeanor that would have landed the perpetrator in jail for up to 3 months. So there are still bans in several states, including, as I found out, in Illinois, where it's still a misdemeanor. You can imagine not very many people were charged by this, or charged with this, I should say, and about a dozen have been charged over the past 45 years. So point being, antiquated law, very interesting that it's now no longer a crime in New York. And I'm sure other states will start doing the same sooner rather than later. And it's interesting because before 2014, at least in the state of Illinois, the grounds for divorce included things like adultery and desertion. So prior to that, you'd have to be legally separated, or at least physically separated, for a certain time period, 2 years or so, unless you could prove that adultery was committed, for example, in this context, in which case that would really shrink that. And then you'd have all these cases where people would come into court trying to prove the adultery. You'd have people following people around, trying to cast them in the act, so on and so forth. So
hire the private investigator. They were busy with all that stuff.
Exactly. So it's interesting.
Yeah, in Illinois did away with alienation of affections and what they called heart balm actions, like alienation of affections. And alienation is kind of the brother of adultery charge, which is alienation is basically you stole my wife or my spouse. It's you convinced them to leave me by, you stole them from me. And now I don't have the, as we would say, as lawyers would say, sex services and society, meaning, the things that a spouse provides, right? So sexual relationship services, like they help me around with the family and everything, child rearing and the home and whatever. And society, meaning a friendship and all that stuff. So we had that crime until around 2015. It was a civil matter, but you could bring a case for alienation of affections in Illinois until 2015. And I'd only heard of one conviction I read about many years ago in Illinois for alienation. And the verdict was like $3,500. Guess it wasn't so good then. Okay, you win, but here's a tiny amount of money. So you can imagine it's an embarrassing case to pursue. And what lawyer is going to take it up? Who's going to take that case? They're going to charge you by the hour for that. Anyway, it's gone in Illinois. And we've seen over time a couple of trends. One is to decriminalize these kinds of things. The other thing we've seen is a trend line towards making divorces easier to obtain and also to take the fault out of divorces across the United States. So there's been a trend towards no fault. And that whole thing has been an effort to make divorces less expensive, less onerous on people, and make it easier and have less fighting. Part of that has been also, we've seen things like the use of formulas to determine child support and maintenance instead of leaving all this wiggle room when really a formula works pretty well in most cases. So there have been those movements over the last many decades. And what's interesting now is there's been sort of blowback now where there's a movement among conservatives, I think we've talked about before a little bit, to make divorce more difficult. And we talked about covenant marriage in a previous show, and there's been some movement to bring fault back into the divorce code, which is kind of interesting because people campaigned and legislate or fought hard in many, many places for no fault. And originally came out of women's rights movements. And now what's interesting is this transitions into our next subject, which is shared custody. There's a movement among really fathers' rights advocates for expanding shared custody mandates, 50-50 parenting time and shared custody, making that mandatory. That's been a push from sort of the fathers' rights side originally. But also one could say it also makes divorce less contentious and simplifies the process in a lot of cases. That's been the general trend, I would say, across the states, is largely has been to make it easier. But we'll see what shakes out in the next 5 to 10 years with attempts to make it a little more difficult. I'm not sure how all that will go. But one example is we got rid of jury trials for divorces, which you can imagine would make a lot of cases a circus, having a jury there and putting on a show and, making it take a lot more time. And we got rid of those, I want to say, in the 1970s. But in some states like Texas still has jury trials, or they're optional, I guess. So it's interesting. It depends on your state.
I think so. The alienation of affection, you could colloquially say, is Mr. Steal Your Girl, right? That's who that is.
That's exactly right. The idea is if you win, you get money for that. Like, you stole my wife and that's worth some money because my wife did X, Y, and Z for me. And now I have to go get another one. And so in that case I read about, I wish I could find it, but I remember reading the verdict. It was like $3,400 or some very small amount of money. It just had to be a very embarrassing case because, you're putting on all this evidence of another person stealing somebody's spouse, I guess, or them having an affair, basically. It also is a sort of paternalistic view of people, like that this other person is so mentally weak that somebody could steal them.
Right.
Like co-opt them. It's a concept of people as property, which I think is the most objectionable concept of alienation, that they have no agency. But what's interesting, if you go way back to our agrarian roots, if you go back and you look at English common law, and I'm getting into law school a little bit here, I guess, and Illinois law, for example, is an agrarian state. We're a farm state that happened to get a marketplace built in Chicago because the railroads had a junction there between East and West. Well, we're a farm state. And this is not sexist to say this, but the women raised children and took care of things in the household, and men worked out on the farm. It's just the way it was. It's not sexist, it's history. Just look it up. So if somebody stole your wife, you just lost the person that did all the stuff you needed to support your household. And now you can't run your farm anymore because who's going to take care of the kids? Who's going to take care of the household and all that stuff while you're out plowing and tending to the crops and all that stuff? So it makes sense in that context, but also offensive to our modern sensibilities, and I get it, of people having agency for their own actions, especially women. And I get it because we sit here today in our society today that has evolved quite a bit.
Right. We're sitting here doing a podcast, right?
Yeah, we're doing a podcast on the internet, and everybody has an equal shot at getting on the internet. It's free. And there's obviously been drastic social change in the last 30, 40 years. So we think of it as an alien world now, but back then the notion was there were property rights in spouses. It freaks people out, but that's the truth. And when you look at those old cases, like part of a personal injury case was you lost the services of your spouse depending on what happened. You might have a claim if your spouse was injured by someone else. You may have a claim as well as the injured person because now your spouse is out of commission and they're not providing the services that they were. So I just think it's interesting to have that perspective. And that's where that all comes from. So we shed some of that stuff over time as we get a little more enlightened, have a more modern view of things. And also we understand people aren't property and people have their own agency.
And we aren't in the times where we used to be, where those roles were so clearly delineated and there was value ascribed, right?
Now lots of people are dual income households, and now our support formula takes two incomes into account. We had a one income model until not that long ago, folks. Summer 2017 was when our law changed to count both incomes. Up to that point, it was as if the other person didn't make a nickel. And it was unfair to the support payors. Usually men, but not always. But it was just the way it was. And it was a system that was appropriate for its time. And then events overtook it. So it makes sense now that we've changed the system. And also we take parenting time into account. So you've probably heard, folks, out there, there's a trend towards state laws that make various aspects of custody and visitation have defaults. In Illinois, for example, we don't have a mandatory law that says that there's joint custody or that it's 50-50 parenting time. We leave it up to the court's determination as what is the best interest of the child. Now, there are rules of thumb. Judges kind of have their biases, things we kind of know as lawyers in the Chicagoland area how things come out. Most cases come out with shared parenting or joint decision-making, which when I say joint decision-making, I'm talking about custody. Custody is the right and responsibility to make decisions for your children. Education, healthcare, religion, extracurricular. So in all aspects of their lives, it's decision-making. Visitation, or what we call parenting time in Illinois, is the time you spend with your children. And that's separate from custody. So we try to explain to people custody and visitation are really two different things. And people blend them together and they act like custody means they sort of own the children. Like, well, if I get custody, my wife won't see the kids, or I'm going to get more time with them or whatever. It doesn't work that way. One person could have sole custody. The other person theoretically could have equal parenting time. 50-50 visitation, even though the other person has decision-making. That might be a little unusual, but that could happen. Let's just give an example. Well, there's been a movement afoot across the United States to, as I mentioned, to push for default laws that presume various things. A big push is for presuming 50-50 parenting time, assuming at the outset that both parents should have 50-50 time and creating a default that that's the case, unless somebody proves it shouldn't be. Because right now you basically have to go from the ground up. If you're seeking parenting time, you're basically just arguing from zero, hey, I need 40, 45, 50% parenting time, 55, whatever it is. And the judge is just deciding what's in the best interest of the child in our state. In other states, though, the default is right off the bat, it's 50-50. And somebody has to prove why it shouldn't be 50-50.
Tell me why you shouldn't have equal time.
Right. And the other interesting thing, though, when I look at the laws, and source was Wikipedia here, so it could be wrong, I suppose, but I checked the states. And one thing that's important to know is your state is going to vary for sure. Only a handful of states right now have some form of default statute. And some of them are custody defaults, and some are visitation defaults, and some are both. And some are for temporary parenting, which what that means, folks, is when you first file your divorce case, what happens while you're waiting to get a final decision. That's what we temporary visitation, temporary custody. And in Illinois, we set up a temporary order. The Illinois Supreme Court has some rules about timing for that. So we have to work out a temporary parenting agreement. And some states have presumptions of how the temporary should work and the permanent. So, by the way, there's nothing that's truly permanent in custody because things change, facts change, the kids' lives change, their needs change. So it always has to be modifiable. One thing to know, rule of thumb, anything about kids is modifiable. You can't agree to freeze something about kids and make it permanent, whether it's child support or anything about custody or visitation. A court won't do it. I'm speaking of Illinois, but I'm pretty sure that I'm comfortable with saying that's probably true across the country because facts change and things have to be flexible. So quick rundown. In Alabama, they're waiting for the governor's signature, presumption of joint custody and 50-50 time. Arizona, they passed a law that considers joint custody. 50-50 parenting is presumed. Considers kind of a cop-out because it's, that's what they're doing in Illinois, really. But they're presuming 50-50 parenting time, which is a step ahead of Illinois. The counter argument, of course, is, and a lot of divorce lawyers make this argument, and they say a presumption of time is against the best interest of the children because it takes none of the facts into account and everyone's circumstances are different. So they say if you just apply a 50-50 stamp to everybody, that's not going to be suitable in all cases. And it's not how it should come out of the box. And I understand that point of view. What's happened in Illinois, the trend line has been to more and more, let's say fathers or more and more of the people that had less of the parenting responsibility, because we have same-sex couples, of course, and everything else. Because of that, there's been a trend towards the parent doing less of the traditional parenting, asking for equal time in divorce and getting it. And I'm speaking about Chicagoland. But in the old days, when I started doing this 20 years ago, somebody would ask me for 50-50 and I would say, it's not happening. It's not even worth your time, because that was true. Now it's happening, and asking for it's not unusual, and people are getting it much more often. So Alabama, presumption of joint and 50-50. Arizona, consider joint 50-50 presumed. Kentucky, temporary and permanent joint custody is presumed. Presumption of 50-50 visitation. Missouri, consider joint, presumption of shared parenting time, which I'm guessing they think means 50-50, though I'd have to look at the law. They made a distinction in Wikipedia to say shared parenting time, which I'm assuming is 50-50. Oregon, considering joint custody, 50-50 is the default parenting time. Virginia, consider shared parenting, which I'm guessing means equal. Wisconsin, presuming joint is in the child's best interest, which is pretty interesting because they're not shying away from best interest. They're just saying there's a presumption that it is, meaning it's rebuttable. And that means somebody could come in with evidence saying, well, joint custody is not in the child's best interest. So really that is not in my opinion, not a material change from what things are effectively like in Illinois. Probably not much of a difference from what it was in Wisconsin. And their term is interesting. Their statute says maximize time with both parents. That's their presumption. They consider 50-50. Kind of interesting. So the court must consider 50-50. The court is charged with maximizing time, but they don't mandate it. So that's a survey of the states. And there's other states where bills have come through and they've got some traction a few years ago and then died. So I'm guessing we'll see it again. So wanted to run that down because it's interesting, and your state may be one of those where this is a factor. Again, this is that trend line to simplifying divorce, kind of coupled with a father's rights, parents' rights movement, I would say, in terms of parenting. One of the things to remember, though, that judges emphasize, and the law says, the public policy is to look at this from the child's perspective. And when parents start talking about parenting time with numbers, judges get a little bit concerned when the parents talk about it as if it's on a balance sheet. That it's all, I want this because they've got that. They're talking about it like the kids are property. That makes judges upset. So word to the wise, if you're in this circumstance where you're in a custody dispute or you're trying to get more parenting time, show how it would be good for the kids, not for you.
Right.
It's all about why it's good for the children. And if you can frame it in that way, you will be much more successful. It's not about, I want my visitation. That's what you're instinctively going to say. It's about the kids need me more often because of X, Y, Z. And I want to tell you, these days, our judges generally favor more time with both parents. And research supports that, especially with young children. So that a lot of this research by psychologists is in that direction, that more frequent visits with both parents are good for kids. Now, we're excluding abuse and neglect and bad parents kind of stuff.
And your mileage may vary.
But that gives you an idea of what that's all about. So we're seeing this trend line to expand these mandates, and you'll probably see it in a state near you rather soon. There are bills that have been attempted that I haven't mentioned in many states on this topic. Okay, now let's move to listener questions, Raul.
Okay. So I'll be the listener and I'll ask you the question.
Well, why don't I ask you the question? Because I just talked.
Sure. Okay. Yeah. Okay. Sounds good.
So this is a good one. A Guardian Ad Litem. So Guardian Ad Litem is a person that's appointed by the court to investigate parenting and custody when the parties can't agree. A GAL, Guardian Ad Litem, is recommending a temporary parenting plan that is for less time than I want. Do I have to sign it? We're 10 months into our case, and I still believe we can get a better plan. Do I have to petition for more time during the divorce?
Okay, great. Well, this is a very wonderful question and actually comes up quite many times. So right off the bat, I'd say you don't ever have to sign anything. You have your day in court and the judge can make a determination after hearing your testimony, looking at your evidence, listening to what the GAL has to say, and listening to the other side. A GAL is a neutral party, a guardian ad litem, and they are tasked with investigating what is in the child's best interests, and they serve as the court's eyes and ears. So typically, more likely than not, a judge is going to be very strongly inclined to doing what a GAL says. So if you don't sign what the GAL says, and you don't have to, it's more likely than not that at a hearing, the judge will probably have some version of the GAL's recommendations implemented as a court order that the court orders, and that's something you don't sign. The temporary parenting plan is always modifiable, at least in our jurisdiction, until such time that it is final. So it's one of those things which is completely your choice if you want to sign it or not. And some schools of thought say, take what you have now and work towards what you want. And others, depending on your circumstance, maybe it's prejudicial to you and you don't want to. We don't know, but you don't have to sign anything. Did anyone have to petition for more time during the divorce? Again, if you want more time, it's your prerogative to petition for more time. No one's going to volunteer and give you more time just because they want to. If you need something, you need to ask for it. And so that's well within your right to do so, depending on the posture of your case and where things are currently standing.
Your mileage may vary. Your state may be a little different in how things operate. So obviously talk to a divorce lawyer in your jurisdiction for more. But this is one of those meta case things I talk about in the book. I have a whole chapter on the meta case, META, which is the case around the case. That's not the facts in the law. That's the judge, the GAL, you, your spouse, the lawyers, and how everybody's perceived. And judges usually like the guardians. The judges usually appoint guardians they like. So these are people they know. They're usually veteran divorce lawyers in our jurisdiction.
And they're trained.
Right. And they go through training. And a lot of times they may not be friends, but they're well known in the courthouse and usually well respected by the judge. And if you're going against the GAL's recommendations, the judge is going to kind of look askance at you like, I don't know, they're going to think the GAL's doing a good job probably, and that you're not playing ball. And that may damage the judge's image of you and the guardian's image of you in the meta case. And you want to look like you're playing ball and you're looking out for the best interests of your children. And this is where people get between a rock and a hard place where they say, I don't agree with the GAL and I don't like what they're saying. Maybe they want more parenting time the guardian's recommending, like in this situation. Well, chances of that you getting the guardian kicked out of the case are like slim and none realistically. And going against the guardian is like not good for your image, so to speak, in the meta case. If it's an absolute and you have no choice, like black or white, well, that's one thing. Sometimes the guardians are just wrong and you have no choice but to chug forward and go to a temporary hearing to get, this is a temporary parenting plan the guardian's trying to propose by agreement. So like Rahul said, you don't have to sign it. You can always have a hearing. And then the guardian's going to make the same recommendation to the judge that's in this parenting plan. And the judge is going to know you didn't agree. And the judge is probably going to order it anyway. And now the judge thinks you're a goofball or maybe something's wrong with you. I'm just saying generically. And now you're kind of looked at in a more negative light, right or wrong. That's the way the system works. So you have to be very careful about how you navigate these circumstances. So I got another question, Rahul, and this one is there some kind of way to figure out what a buyout is worth? And can you explain how you might calculate that? And then also the considerations somebody should think about that are sort of beyond just a typical math analysis of like present value, for example.
So very, very good question. There is a formula. There are several formulas, but there is no the formula, meaning the state of Illinois does not promulgate a formula that's a statutory guideline like the amount of maintenance, for example, for purposes of a buyout. A buyout is not something a court would necessarily order. It's something that parties enter into voluntarily. And so there are several different ways to calculating the buyout amount, along with, like you said, Rafe, several factors that'll weigh in on the amount, payment duration, and the discount that may have to be had. So a buyout is basically where in lieu of having this annuity of X dollars per month for, let's say, $1,000 a month for 36 months. Rather than pay that amount for 36 months, what can I give you today and just be done? I don't want to pay that. And the initial thought would be, well, hey, 36 times 1,000 is 36,000. So that sounds like a good number to me.
Right.
It sounds like a great number. But a problem is 36,000, it's not a dollar for dollar equalization because of the time value of money. $1 today is worth more than $1 tomorrow. So having $36,000 today is worth a lot more than having $1,000 a month for the next 36 months. You can invest your money, you can buy something, you can certainly grow that 36,000, which would otherwise not be available to you until the end of 36 months and until such time that you've saved it. So, and the 36 payments, $1,000 payments are interest-free payments. It's not like they're paying interest on that. Additionally, there's certain things to think about because a buyout essentially lets the other person, quote unquote, off the hook, the recipient. You could die the next day. They could die the next day. They could turn around and get married to somebody else the next day. And you don't get to ask for money back.
Right.
You've given the money, it's done. They get guaranteed $36,000 that they would have had to wait and not get married until the 36 months, for example, so on and so forth. So, I mean, these are just examples. You're avoiding the modification factors, you're avoiding the termination factors, and you're getting all the money up front. So what is that worth to somebody? Besides discounting it and typically we discount it by, the T-bond rate that's going on currently, the discount rate, the treasury rate currently, which would be 4 or 4.5, whatever it currently is on this day. But you would discount that back to today. So the 36,000 might actually end up being like 33,000 or 32,000, whatever it might be. And you discount it further, or I advise my clients, if that was the case, to discount it further for taking into account those other factors we just touched on. And there's no formula for that. It's really just, what's it worth to you?
And as you go longer, those uncertainty factors get more probable.
Yes.
Death, disease, somebody not disability, somebody getting fired, somebody getting remarried. If the timeline is longer, one could argue we need deeper discounts because all of those things are more possible over a longer time horizon. So it gets harder to negotiate a lump sum if the time is longer for that reason, because there's a tug of war on all those factors. The discount rate is easy. Most people agree it's a 20-year T-bill rate, risk-free rate of return. Discount rate is interest in reverse.
Exactly.
And so you can run a calculator on the internet. If you type present value calculator on Google, you'll get 10 present value calculators, and you just can type in the amount, the reverse interest rate, and it'll back that number up. But like Rahul said, then you start the real log rolling. Okay, that's the present value, but then there's all these uncertainties. And what's that worth? And also, how much is it worth to get the money today to the recipient? They might need cash. They might want to buy a house, or there may be variables involved. And they say, I really want the cash. It might be worth more to them than somebody else. And there's room to negotiate that. And so, and you're looking at this from both sides. So when you represent the person who's the support payor, usually when the time horizon gets longer, a lot of times you recommend they just pay maintenance, because a lot of times the discussion gets to be impossible. Just reach loggerheads, and you want a deeper discount than the other side's willing to give, and all that stuff. And so you always can fall back on statutory maintenance, and so the advantage for the payor is everybody knows that if you go to court, that's all the judge can order. There's no lump sum maintenance. There's no present value calculation. The court will never do that at a trial. That's only something can be done by settlement in Illinois. So that can be a point of leverage.
Oh, but great question. Very good question.
Those are good questions from the listeners. Yeah. So a couple of things. Wanted to point everybody's attention to a couple of things. One, our law firm, STG Divorce Law. We're in Chicago. We're also in the surrounding suburbs. We're here to serve you. We just had another attorney join our team. We're ready to serve you across Chicagoland. And our law firm's website is stglawfirm.com, stglawfirm.com, or Google STG Divorce Law. We're easy to find. I am all over social media at Rayford Palmer, easy to find on Twitter, or X, Instagram, TikTok. We're on LinkedIn, Facebook. We have a private Facebook group, the Illinois Divorce Support Network. It's free to join. Links will be below in the description. We've got this podcast. And of course, as always, I have to show our book, I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds. This is a bestseller. It's on Amazon, Audible, on Kindle, and where all ebooks are sold. And I'm working on my second book, I Just Want to Know, which should come out in the first quarter of 2025. So check this out. It's on Amazon. It's got great reviews, almost 100 reviews, 4.7 rating. Rated the best family law book of all time by Book Authority, #1. Check it out. You'll love it. It's not boring stuff. This is ungoogleable information. I spilled the tea on the system. So Rahul, where can people find you online?
Yeah, well, people can find me on LinkedIn at Rahul Iyer, or on Instagram at Chicago Divorce.
Check out our other episodes, and thanks very much for watching. Please drop questions in the comments, or like I said, we can email us also, and we're happy to answer in future episodes. Thanks very much. Have a great day.